Good morning, ladies and gentlemen. I hope you had a great evening yesterday. I have been asked to rush through my session, 5 minutes important. First of all, I would start my lecture quoting my Indian government of daylight. This is what it says. There is a pressing need for courts across the judicial hierarchy in India to remedy the individual problem of bail application not being heard and disposed of with expedition. Every court in our country would do well to remember Lord Lenin's powerful invocation in the first 100 days of freedom under the law. Whenever one of the judges takes a seat, there is one application which by long tradition has filed over all others. The counsel has but to say, my Lord, I have an application which concerns the liberty of the family. And forthwith the judge will put all other matters aside and hear it. Justice Chandrakant in A.M. Goswami versus the state of Maharashtra decided on 27 November 2020. As you all are aware, our bail law is governed by 3 acts. The first is the Constitution. 13th Constitution talks about freedom of penalty. Then the 1997 Bail Act and Criminal Procedure Code and various other acts which are coming into play time to time. First of all, as you all know, Section 2 of the Bail Act is there has to be granted except not granted of bail. But our Bail Act has specific sections where up to 70 bail has been granted. Except in ungranted bail, only bail under the Bail Act, bail cannot be granted comes in section 14 of the Bail Act. There are only four matters where bail will not be granted. One is such a person would not appear to stand his inquiry or trial. 2, such a person interferes with the witness or the evidence gathering or otherwise obstructs the course of justice, or such a person commits an offence while on bail. That won't happen because they have to go out on bail. That will happen. That the particular gravity of the public reaction to the offence may give rise to public distrust. Those are the only 4 reasons under the Bail Act. Bail can be refused. Now, most of the time, this is the law in the penal code, except for sections 140, 191, and 296. All the other offences in the penal code are bearable by the magistrate. And the other acts also, specific acts are there. Some sections of those acts, some offences, you have to go for bail to either the High Court or the AG. In Sri Lanka, presently, there are no criminal law offences which are non-bail. Every act, even the most draconian law, prevention of terrorism, special purposes act also, section 15, is the authority of the Supreme Court to grant bail. If the case against the accused has not come in within 1 year of his arrest. So there are 4 judgments. Justice Kumaran has delivered, I think, just last Friday. 398, 24, 399, 300, 400, and 401, 24, where a person who had been remanded for over 1 year had been granted bail under the BASL. That is one. Then, our courts, especially the courts, are aware that bail has been granted. But our bail act, section 14 is a very dangerous section. Because before 1997, I don't know whether you all are aware, whether you are started your practice before 97. Before 1997, before this bail act came into force, even a murder case, if the police did not file a claim within 3 months, the magistrate court had jurisdiction to grant. Now, present day high courts, if the non-summary proceedings are not concluded, they will grant. But that is against the bail act. The bail act does not say that non-summary has to be concluded. Only way, if you go to the magistrate court, one day they might be the why the bail of they are right. Punishment also that is no reason not to grant. That comes under the other section, interference with the witnesses or the evidence. That is what they should write, but they write punishment also. Punishment also cannot be given because they might interfere with the resolver if this can be done on that bail can for 2 weeks. Before this act came in force, the bail offenders, we had a right, as of a right, we could go to the magistrate court and demand bail. The criminal case was there, all those cases, specifically, bail has to be made. And even non-bail matters, the maximum time the person could be kept in remand was 15 days. Presently, even if the matter is 340, 350, 40, anything, if the police file report under those 4 subsections that I mentioned, you can be taken in remand for 1 week. That can happen. So, the bail, though it says bail is the rule, none of bail is the exception. I think this bail has created a lot of problems. It has created problems for the practitioners because if the police is administration, they can use the simple report happens. That is one. Then, talking about the bail concept. This bail act overrides all the acts except for one act, that is the Release of Remand Business Act. Other than that, it overrides all the acts, even the Criminal Procedure Code, it overrides. Section 27 is very clear on that. Bail act section 27 is very clear on that. So that is then. I will talk about the special acts that how and why they can be granted or not. First one is poisons, opium, and dangerous drugs, number 17 of 1929, which have been amended recently in 2022. As you all are aware, before this Act number 22 came into force, bail for heroin matters, whether the quantity was 10 grams or 100 grams, was the high court in the country. Presently, the jurisdiction is registered with the appeal. So, if a man is found with 10 grams of above heroin, methamphetamine, or IVs, he has to come to the appeal court. So, man in Jakarta, man in Bangalore, man in Bidau, man in Bangalore, 11 money, waste carrying in the appeal court, get bail in a heroin matter. So, I can't understand how the system and the politics of the legislature can change the justice through the evidence.
I wrote to the minister to bring it back.
That is that I agree that understand. So that is a big problem. So that is a simple amendment. They would just take that off. So this the other thing is this now. Who has the jurisdiction to take this work is the High Court. High Court can hear the case, sentence and do yes. But they are not paid. So where are they? Whose interest was this amendment? So that is interest of the amendment. So some politicians for them to earn money. Oh, that is one. Then this uniformity in granting bail. That's another problem. Certain jurisdictions have come with Up to 10 grand, if there are previous conditions, mandatory doesn't wait 1 month or 1.5. There are two basic coaching around both the course like that. There are places like Candy, BASL, Ego, and some other places called where they are within 2 months. There are no previous conditions. That is the way. So there are certain jurisdictions. Even for 2.5 bands, bands is getting demand for 8 months. So that is there are so uniformity of brand way. So what happens is all these confused are in some business idea gold like or that so they discuss. So banking jurisdiction comes out in 1.5 months. Bank is some other jurisdiction waits for 8 months. So ultimately, who suffers? The council to organize the country suffers. He will come and ask, sir, I'm asking now. So these are problems. So it affects the whole system. Those can be addressed and changed. I undertake that those things can be changed. Uniform. Certain courts, they, I quoted that Indian government. They is important, freedom of person. So, if a bail application is filed, if the notice interval date is 3 months, there is CD. Where is CD? So, there must be a strict look at it. That is also where the notice interval can be 2 weeks, 3 weeks maximum. So, then the date when the objections are filed, if the state council wants a date to file objections, that will go down by another 3 weeks. Then they file the objections. Certain courts, the equality is 3 months. So the marriage is demand for having 12 months or going for 8 months. So those are the practical problems that we have. Those have to be addressed. Then that was one thing. Then the other hand, Exclusive Act, there is one section where bail you have to go to just a specific court mention in that. So when there is a specific court mention, you have to go to the state court to get bail. Next is the Immigrants and Immigrants Act. There is one section where you have to go to every court to get bail. That's why I just mentioned that there are no laws in the country where bail is not granted. In every case, data is granted, as you all know. And when we data is pulled out of started. So there are the AC council says they are not objective bail is granted. Even if the law says bail cannot be granted. Then the next one is the customs ordinance, also I spoke. There's one section, there's no specific the jurisdiction in the High Court to grant bail in one section of it. Marriage Pollution Prevention Act also there's one section. Convention on Suppression of Terrorist Financing Act number 25/2005, there are also no specific jurisdiction mentioned. Then there's another thing which you all have problems. That is the Offensive Weapons Act. I know there are police officers here, senior superintendents, assistant superintendents and CIs. Basically, what is an offensive weapon? Anyone know what is an offensive weapon? Can anyone say, other than police officer, one SSP can you tell me what is an automatic weapon? Can anyone answer the question? What is an automatic weapon? No. Automatic, you should go.
Manual feed current network.
Oh.
The gas value split automatically.
Maybe one thing is
One by one.
One by one. On this act is Offensive Weapons Act. No, it's firearms ordinance. The automatic weapon of automatic weapon is available by high. But most of the time, when police find 9mm revolver, 9mm semi-automatic weapon or the revolver, they report that under paragraph saying that this is an automatic weapon. So what does the court do? The magistrate, most of the magistrates are not aware what an automatic weapon is or what a semi-automatic. They send it to the government and to see whether this is either automatic weapon or semi-automatic. So what happens? It takes about 6 months for the government has report to come. So until such time, unless he can report to the High Court and get paid from the High Court, he has to be incarcerated for 6 months to get paid. The problem there is now police are supposed to know what an automatic weapon is and what is the semi-automatic weapon. There are two types of weapons. There are variant has to be audited from the High Court, that is a fully automatic, like 350, 60, or automatic rifle. And a repeater shotgun. For those you have to go High Court get paid. So if the magistrate is not aware of what a semi-automatic weapon and an automatic weapon is, she will send it to the government. The idea of it is every police officer is trained in the use of firearms. And especially the sub-inspector who is in charge of the station is trained to use a 9mm or revolver. So he knows that this is semi-automatic weapon. So I think that information is by saying that whether this is an automatic weapon, it goes to the government. The problem is in Sri Lanka there are about 4,400 handguns earlier. Now I think it's down to about 1,500 handguns. No licenses are not issued to automatic weapons. Licenses are only issued to semi-automatic weapons. So those weapons, every year it has to be shown to the police. Then they find a report that the license is issued every year. So if that is the case, why should the gun be shown to the police? Gun has to be shown to the government. So all the weapons will be taken to the government, whether it is automatic or semi-automatic. So that is the problem that people have. They are not trained. The police officers are not trained, or they don't be able to keep the man in one. It's a big problem that we have on the firearms ordinance. Then, offensive weapons act I spoke about it. Earlier, the notification to grant bail was in the appeal court. Now we take come to the High Court, so we can get bail from the appeal court, High Court. We have to satisfy that yes, exceptional circumstances. Done. Then the other thing where we all have a problem is this anti-police ordinance number 9 of 1940. That is an act. It is anti-gay. That act has to be either abolished or the new act has to come. Now, for an example, you can be hauled to court for digging for a taxi pay or a bail. That act is draconian. You can just bring someone and demand him, and there is no bail in it. There is no bail until you release or you are punished or you get another track. There is no bail. Now, presently, some payors grant bail sometimes, looking at the tax of it, they grant bail. But in the act itself, there is no bail for under the activities ordinance. And the first thing is you have to wait for the Director General of Archaeology report under 15 of that to see whether this is the archaeological site, whether it is gazetted, even if it is not gazetted these days, there are some some things that the report says that this is a site, archaeological site. That is one of the evidence where not to learn as long as this can be archived. If the report comes, you are income. If the report comes and says this is not an archaeological site, then nothing has been damaged there, then the man has to be discharged. But if such a time the report comes, easy become. So that has to be changed. Now it's a mental intention. Now I can what they make a mistake is, under ordinance, there's next one, pressure, next to this until ordinance is the pressure. Under this ordinance, a man can do all the country can the like oil land, have everything, have a land, trigger for a well or water tank, underground water tank. He can do it. Or he can not do any of those things. He can get a bulldozer or a backhoe and just dig without doing anything. But he still thinks that they are taking information. Like they say, read to animals. So the media cannot be what the man knows has in his head, how can the police find do? So that's why I said, even building a laboratory, building for a laboratory, he can take all the food and demand. Then the Public Property Act you all know, and then also you have to exceptional circumstances on public property also, and the jurisdiction presently under exceptional circumstances they can be granted by the state court, or you can do an exception to the high court. So general application about exceptional circumstances, there are grounds that I have got by doing my research, updating my research, and the courts, Supreme Court, the High Courts consider certain things as exceptional circumstances. So these are the basic things. Sole breadwinner in the family, children's psychiatric difficulties, older parents, sole caregiver, demand time, pure quantity. Then guilt of being after another. Any other which shocks the conscience of the court, financial difficulties and diseases. All some of them together. COVID time there are special circumstances, people who ask to be released expediency. Presently, our demand can do 30,000 business. There are 33,000 business in the demand. Like I said, under the new drug law, section Act number 22 amendment, because the judicial drug ladies in the report, there are about 600 pages pending in the report from right from the market. So the report has taken by some cases, waiting for the government report. When I went to the government department for 6-7 months back, they said they were still going through 2023 cases. So by the time the government report comes, it will be 1.5 years these people have done. And the government has specifically informed the police as well as the AD department that in heroic cases, if the gross quantity is 10 grams, maximum or the average maximum quantity will be 15% of that. So that is 1.5 grams. So if the gross quantity is about 10 grams, automatically you have come to the every court case. So ultimately, the report comes after 6 months, after 1 year and a half years, quantity is 2 grams, 3 grams, 4 grams. So that man has been incarcerated in the remand for about 1 year. Till that government has to change these laws, have to change. Then, talking about bail, like I said, is uniformity granting bail. There's a case that I want to talk to you about. This is that I think already get that reference. It is a Kandy High Court case. High Court case number HC 141 of 2020, where there are no judge. It was a very issue case. Issue to the first time because this accused came on bail. Because people may not come back again. First time because then the man was remanded, saying that there was enough evidence to convict this man, so I am remanding for 3 months. The day was 4th of October, he was remanded till 1st of January. And though the state council wanted witness to be summoned, that never happened. No one was able to summon witnesses. So even if it was or the 4th of January, it will have to put up for America and this man would have been in demand. This case, I went on the bill. I went on the bill. CPA 132 of 23 decided on 31st January 2024. That is the latest law on bail. Justice, His Lordship, Sampath American has analyzed what is bail, how bail can be refused, how any court can, the judge will be very clear on it. I'll read part of it because it's very thought-provoking. In this judgment, Justice Sampath American says, Section 263 of the Criminal Procedure Code is redundant. What is applicable in bail matters, especially under the Criminal Code, is the bail. Section 27 is very clear. This is what he says. He has quoted Arul Ratha's case where there was a first judgment regarding bail. Then he has quoted, in Verbatim, he has quoted the Rupatunga versus Attorney General and another 2009, one SLR and SOT case. It says, these are orders which could be found as capricious, arbitrary, and unjust. That shocks the concerns of this court is that the High Court judge has not even dared to provide an opportunity to the accused, at least to show cause as to why bail should not be cancelled. Instead, has considered some external matters which are not even covered by Section 14 and has rushed to the conclusion that bail should be cancelled, which I say is indecent. The judgment court. So, when a man is remanded for 3 months, ban comes on bail, which cannot be done. So that judgment is very clear. It is analyzes what bail is, where bail can be refused under Section 14 only. Not for. They can't ask the right to conclude investigation, but they can say that we can interview. Presently, sometimes police file report facts under 296 in bail life. So no one is saying, you and I are not saying because you drive a vehicle, maybe under the influence of the but you have no intention of killing someone. And you don't know to use a vehicle in a head-on crash to eliminate someone. Because then you can be suicide. So that's all happening in those matters also. I know a case man, and I used to get license in demand for 92 days. The way must be like about problem because I'm is one. Then there's another judgment. This is also one of my cases. There are the High Court Judge of Chila. The early case of High Court Judge of Chila is High Court Judge of Chila. Certain accused was produced in the Master High Court, and the counsel was made for that that's the produce. That's to produce Chila. So, to the same time, the department, they filed the indictment High Court of Chila. Then, the family department as a misappropriate charge, producing a forged identity or something in the court. That's how we charge, one small matter. But the Reverend High Court Judge of Chila refused bail, obviously for 1 year, bail has to be done. That's the law under the bail, section 16 and so on. So, in this matter, and again, His Lordship Justice Sampath American gave a judgment. But this matter is Chila case number 14 of 2023. Court of Appeal case number CAPHC APA 131 of 24. In that judgment, the learned appeal court judge, His Lordship Justice Sampath grant that bail immediately, and he made a bail order how bail should be furnished. This order will be, 18/12/2022. This order is because of the shifting of the report, it took some time for this order to go to the High Court, but anyway, some time they were not granted. This man was incarcerated for another 5 extra months. Then ultimately, the petition is the petition to the Supreme Court and the AC, saying that this man has not been granted. So the reason was that the one of the sureties, that the petitioner must be one of the sureties, petitioner has had some argument with the court of law. As you know, the brother or husband is in one for 2.5 years. They are also very emotional. So on that, it is just not done. So then again, the petition, and once the JC and the article, Honorable Chief Justice, and then only about the after 5 months, they will make it. 5 years. If the judge can't follow the ethics of God, they are if the magistrate don't realize the High Court orders, they are not getting. Now, that is what I come to this most interesting judgment of Justice Yasanta Kauda. His Lordship, the latest judgment, SCFR 346 of 193. Yeah, this was decided on the 3-day judgment, decided on the 3rd of July, not even 10 days. In this chapter, here they are ordered by chapter 79 is what it says. This court notes the compelling need for magistrates to be educated on the need to take judicial decisions without functioning in a perfunctory manner. With regard to application by the police to place suspects in remand custody as recognized by the data, the governing principle is that while grant of bail is the norm, the refusal to grant bail shall be the exception. While it shall be lawful for a magistrate to refuse to grant bail and place the suspect in remand custody, he shall do so not for the mere asking of by the police, but for valid reasons which are in conformity with the objectives of criminal justice. That is the bail and shall go. Beyond that, they can't. You have to do it as a offense, has to be acted under. Then, magistrates must be actively conscious that the judiciary is also duty bound to uphold fundamental rights of the people and should make orders restricting the exercise of such rights only in exceptional circumstances. That is very important. For valid reasons recognized by law and take such decisions in the manner provided by law. It is the expectation of this court that the Judges Institute will take necessary measures to educate magistrates and on the principles contained in this judgment. That is very important judgment, and I hope at least this judgment will pave way for people to be released on daily according to the law. Then I run through, I will. Now, I will
excuse me, sir,
yeah.
the last judgment had to be and she is repeating
That is Justice Yasanta Kauda
Yes, sir.
SCFR 346/2018, decided on 3rd July 2025. Yeah, sir, unless I haven't that I was unable to raise it. After this Angel class of 2022 getting in force, the period of remand below telegrams was very 1 year. After 1 year, they had to be done. So there was a facing day all former judge, which is retired now. Kept a man for 3 years. I made about 4-5 years in the High Court, it was not successful. So they also I made the appeal court. And appeal court here, I could not make a judgment. That if it's zero then 1 year remand the maximum, unless 80 days becomes the subpoena, remand can be extended every 3 months. So that is also done, and then that was always quite a lot of people to get people out. Even this can be case, there are about 8 matters where after 1 month witness only, people have been remanded post-case postponed for 3-4 months. And ultimately, a lot of things happen after that. So now that is the can be. The research is done, and it was, I think, there was an article about this judgment of this candidate people here. Where they will, however, and why it should be granted the procedure is possible, or if a witness interferes with the evidence or tampers with the witnesses, tampers with the evidence or interferes with the witnesses, only the person can be remanded. Otherwise, bailable offences, non-bailable offences, there should be granted. So, when you make an application in the magistrate court or you put your case to sign these cases and say that bail you granted bail and non-bailable also. Bail should be granted. Earlier the law was 15 days. I still think that bailable offences bail should be granted. Non-bailable offences was after 15 days bail should be granted, whatever the bail act says. Otherwise, the whole concept of the bail act is lost because it says section 2 says granting of bail is the norm, exception is not done. But it works the other way. Like I said, it works the other way because even on the removing matter, if they come out the section 14, those subsections, 4 subsections, man can keep it remove only. Even for a 340, 48, anything. These are matters that the vice president will take note and they represent change laws. Either the bail act should be done enhanced or new bail act should be built. Just that. Because the bail act gives just a clarity that ordinarily most of 20 years talking of anticipated bail. That's another interesting subject. I think in this country, from the day of this act, 1997, I think I don't think there have been 10 applications which were accepted by court and court. I think in my life I have only one anticipated bail matter. There is came post that was in 2000. In 2091 case, and there the state under the and he gave me anticipated bail. But presently, I only even cases similarly successfully obtaining anticipated. So I don't do anything just because I know its uses. Once I anticipated bail is filed, the court will ask me the question. So I don't think I don't know the reason because they want to have successfully anticipated. I don't find anything. So that is, I think I hope I covered most of the things. I will take some questions if you want, I will answer. Any questions? In senior law, it doesn't matter.
Exact. It says charged of or yes, charged or accused of. Does that mean suspects can be not?
Yes, no, they can't be convicted. No one can be convicted. If you are caught up in that act, you can't be convicted.
Even you're a suspect.
All suspects know in their they are not being convicted.
It says charged or accused.
Charged or the same thing. So till they are charged, what I think is, if the police are not aware whether this area is under the archaeological commissioner, it's a site where it's an archaeological site, or some specimen was from artifacts. So, if the police are not aware, how can the accused of him be aware? So, you have to wait for the report from the technical. So, the electrical report, you know how electrical report operates. You have to go behind a lot of people, palm, or in their palm, then they come. They report 1.5 hours, they will come. So, till that time, they come. So, what they should do, right? They must file another report. It's like element task. They don't know it is element task. They send it to their veterinary hospital to find it is element task. So that the man is in remand, these are importance. So what they do is file a report that's it. We don't know what it is, so they are asking this to be sent to the veterinary hospital or the veterinary. Now, I think it is all. So till that time, that man can be contemplated. If the offense falls within that one, they are also beyond how the man can be. You understand what I'm saying? There are no questions. I hope I have enlightened you all, and I hope you all will use the knowledge that I gave you and the case law that I gave you to defend in the magistrate courts and the high courts and be successful in the because these days there is the best practice ever. Because there are so many cases, a lot of people are going to the court every day in the magistrate court, sometimes in the high court in time. So be very educated and be very aware of the law and try to make the maximum of it. Thank you.
Thank you, sir. That was provoking, engaging, and inspirational discussion on the law of faith in the Sri Lankan court system. To appreciate Ms. Kumar Devan, Business Council's contribution to the success of our session, I cordially invite Mr. Mandavani, convener of BASL Webinars and Symposium Committee, to present the document of appreciation on behalf of the committee. So our next session will be on interpretation. So our resource person is Anna and we will begin the session shortly. This was a Mr. Sri Lanka, a well-respected legal professional with extensive experience in both public and private sectors. Mr. Sara has contributed significantly to the legal field through his work in litigation, legal consultancy, and public purpose. He is also competent in legal education and capacity building initiatives in the profession. Yes, sir, the stage is
Good morning. So I was told that I will have 15 minutes less than 4 minutes. But we will have to summarise Anything summarized. This is what it is. Before I came in, I sent to the various certificates of decisions, publications, counter-categories, and implementation decisions. I hope one has got those. But I think it will not be I'm not going to be talking more meetings because there is no time to do that. What I thought was my endeavor to, in the short time that we have, to give you some practical insights as to how interpretations work, what are the fundamental things that you should get, how you should approach it, and the very basic parameters in the judicial category. So I don't see any problem. This is another that or when you see practitioners or thereabouts on a basis. So as you know, the jurisdiction that is given to the courts in terms of our constitution is the Article 104. Article 104 has given the court of appeal the jurisdiction to interpret the law, issue rules of social area, mandamus, prohibition, and code. Now, of course, that jurisdiction has now expanded to provincial high court. So, the first thing that we are going to do is take your court. The court of appeal that has no jurisdiction, issuing specific of both the reservists, contractors, and the provincial council. So, any executive administrative judicial action, the court of appeal is very allowed and entertain those. In respect of the provincial high courts, they have the jurisdiction to go in matters on the contractors as well as the provincial councils. Sometimes there are some characteristics, but certainly those are the broad parameters of the jurisdiction of the courts. So, what will be anyone on the basis of the provincial high courts, contractors, and the provincial. Now, as I said, there are four main bricks that are looking at social right, mandamus, prohibition, or so social right would be the limit that would need to wash, to nullify illegal actions on the part of or illegal judicial. Prohibition. The prohibition is protected. So, in terms of social right, would be in respect of something that has already happened. So, you're looking at something that has happened, but prospectively, you're seeking a limit to wash it in the point that you're going to. In terms of prohibition, you're looking at acts which are illegal, those are proscribed. Then the third most important point, I will not focus on the word here. Third most important point is the theory of mandamus, which is to compare these state parties to take steps that they should. But they are not. I will look at a little point here my presentation. If I can just say maybe as you know, the origins of the jurisdiction stems from thinking. Because initially, some hierarchy were used by the king, the monarch itself, to show various leaders to compare certain actions taken. This is all when there was a background of various lords and other normal people who take the king used to say to rectify those mistakes because that time we vastly all to what we have done. Now, the first thing as I said, that we would better application side on forward, whether they photo be logo or whether they be a production site. We find that in the production site also, there are many instances of application. Then the next thing you need to look at is to see whether you have the lowest standard application. So once you decide on the photo, you must decide, do I have the lowest standard, the legal right to be a petition? The law on lowest standard has changed from what it was before to what it is now. The old lowest standard law said that the petitioner you must be directly affected by the act or omission that you are doing. So, if you do not have a personal direct affiliation, you could not be a petitioner. That's how it used. Now it has evolved, and actually there has been a development law as a discussion. And the current law of standards is not only can a person regulated by the people that the application, but anyone genuinely interested in that particular matter can come before. Because of that, the area of public interest representation has now been vastly expanded. So even if you have no direct affiliation, but if there is on the basis of something happening in the country which is extremely illegal, it's unreasonable, there is some arbitrary action taking place, a public spirited person can come into the court and ask for the report. So now, as things stand, almost any genuine public spirited person can come before the court and see the verdict. As long as it's a genuine interest, it's a bona fide interest, and it's not as a mere disease. So that is how we decide as to whether they are opposed to that. Then, of course, you have to decide on the respondents. You would be the petitioner, of course. Then you decide on who the respondents to this application should be. So there are three types of respondents that you can include in a written application. Firstly, the person or persons who was directly instrumental in the decision that you are taking. So it could be the person under whose hand the decision was signed, or the person who directly took that step. So though that would be the first category of respondents. Then the second category of respondents would be persons who may have in some way or the other influenced or coerced that first category of response. That is what we call command response. So for example, if you are challenging a decision which was communicated to you by a director in a particular department who was directly responsible for that area, you could make the head of the institution also respondent by virtue of the fact that they would have had command responsibility and in some way influence that decision. Then the third category of respondents would be persons who would be affected by the relief that you are seeking. So for example, if you are, let's say the example of someone in a land development ordinance issue where an LDO permit has been issued to someone who has no entitlement to that permit. You are coming before court, saying that in terms of the law, that particular eligible permit should have been issued to you. Then apart from the officials involved in that transaction, the persons who issued the permit and the department, there is also a private citizen who would be affected by the relief that you are seeking. Because you are seeking a writ of certiorari 1 to quash the new permit which has been given to that person. Then 2, a writ of certiorari mandamus compelling them to issue a new permit in your name. Either way, that other private party is also affected. So they also have to be in a party. So the 3 categories of respondents: the person under whose hand, the person who directly made the decision that you are challenging. Secondly, the people out there who may be responsible in some way for that decision-making process. And thirdly, the party or parties who may be affected by the relief that you are seeking. Now, bear in mind that writs are discretionary remedies. And there is a fundamental premise that when you come before court, your pleadings must be complete and they must be proper. If you don't take those steps, your writ application can be dismissed at the very outset without the consideration of the merits. So when you are deciding on who your respondents are, you must be very careful and make sure that you don't leave anyone out. Because if you do that, you are standing in a very dangerous place that the writ application will be dismissed at the outset. So, those are the respondents. Now we are discussing forum, we are discussing local standard in respondents. Now, when you come, as I said, in a writ application, you have to be very careful about your pleadings. And the courts, particularly the Court of Appeal, rigidly observes the principle that a petitioner who comes before court seeking a writ must come with clean hands. You cannot suppress any material. Sometimes there is a tendency to think, well, certain documents that you have seen are not very favorable to you, so let's not annex it to the petition. That is a fatal error. You can't do that. You have to disclose matters which are both favorable and unfavorable. You have to decide on how you are going to explain away the unfavorable documents. Because the chances are, even though you do not present it in your petition, the respondents, when they come before court, will do so. And the moment the court feels that you have not been entirely truthful with the court, the application will be gone out, regardless of the merits of the case. So that is something that you have to be very, very careful of in a writ application. Full disclosure. Full disclosure of your matter. Then the other factor that you have to be careful of is lashes. That is delay in coming to court. And that is based on the principle delay defeats equity. Now, unlike in a fundamental rights application where you have a constitutionally prescribed time limit, it is 1 month. In a writ application, there is no prescribed time limit in which you come before court. But through a process of judicial interpretation, the courts now accept that you have to come before court within a reasonable period of time. Now, what that reasonable period of time is not defined. It can change and vary according to the situation of the case. Sometimes we have challenged decisions which were taken 56 years prior. It has worked. Because unlike in a fundamental rights case, where the courts have held any attempts that you make to administratively resolve the matter, to settle the matter, to make representations, appeals to various parties, including political authorities, does not count. In a Nepal case, none of that matters. If you do that at your own peril, the one month will run. In a writ application, the authorities say, no, those matters will also be looked at. So if you have been engaged in a genuine attempt to resolve the issue by writing to the parties concerned, and there is evidence that there has been a back and forth, bona fide back and forth, those matters will be considered by the court as extenuating circumstances and will go into consideration by the court as to whether it's reasonable time or not. Now, if you come to court late, you have to explain, as I said. So you have to explain and say, well, we have been having this back and forth, communications have been going on, they made representations, they told us we will do this, but we need to explain. But there is one exception. The principle of lashes will not apply if the decision that you are challenging is a nullity. If the decision that you are challenging is a nullity, that is to say that there was absolutely no legal basis on which that decision or determination was made, regardless of when it was made, then lashes will not apply. Say, for example, if you look at quick notices under the state plans recovery of possession law. Now, the law is very clear as to who can issue those quick notices. That's the state plans, so it's usually the divisional secretary, or the authority under whom that particular land has been vested. So we have had certain instances where the forest department, for example, the forest department, even though that particular land has not been vested in the forest department, where it has not been gazetted under the forest department, and it remains a state land, some over-enthusiastic forest department officials go before the magistrates court and file action for eviction. Now that is a nullity. That is a nullity because they have absolutely no legal power to issue that writ notice. Could have only been done by the division. So in such an instance, the principle of lashes does not apply. You can come before court at any point. That is just one example. Just keep in mind, if the action that you are challenging is on the face of it a legal nullity, the principle of lashes is not apply. Otherwise, you have to come before court within reasonable time. Now, having considered those positions, the basic position of forum, or who stand by, who your respondents are, whether you are coming before court on time, whether you are coming with clean hands, without some adverse elements that you can consider, then you can consider whether the case that you are presenting to the court has a legal basis or not. Remember, writ application is not an appeal. That distinction has been drawn by the courts over and over again. A writ application is not an appeal. It is an application for judicial review. There is a difference. And how the courts look at it is, we are not looking at whether the decision is right or wrong. We are only looking at the procedure by which that decision was reached to see whether that was correct or not. Not an appeal. The courts will look at process, procedure, the legality, not whether it's correct or not. There is a slight overlap, I will go into it. So, When you are challenging, now I'm primarily talking about writs of certiorari. When you are challenging a particular decision or determination, these are the matters that the Court of Appeal or the Provincial High Court will look at in the first instance. They will look at whether the decision is ultra vires. You know what that means? That means beyond the scope of the legal authority given to that particular person or entity. Is it outside the law? Then the Court of Appeal or the Provincial High Court, we look at whether the rules of natural justice have been followed before that decision has been given. Were you given a hearing? Was it an adequate hearing? Were you presented with material which is adverse to you so that you could present the defense? So the rules of natural justice has to be observed before decision is made. If not, that is amenable worry. Then the courts will look at, is the decision proportionate? So the decision maker may have the power to come to a particular finding. It may be supported even by the evidence, but if it is disproportionate, then the courts can intervene and say, no, this is not fair. That is a subcategory within the area of reasonable. It's an irrational. So the courts can look at whether a decision or determination that you are challenging is reasonable, rational, and proportional. If it does not meet any of those three, then that decision can be quashed. Right? Then, of course, the more tricky area is that the courts can also look at whether there has been bias, whether there has been malice on the part of the person or persons who gave that decision. So, those are the areas that will form the basis on which your case will succeed or fail. So, having fulfilled all the previous criteria, you will have to look at the case, look at the presented evidence before you, document the evidence, facts and the sequence of events, and historical antecedents, and decide, is this decision ultra vires? Is it illegal? Is it irrational? Is it unreasonable? Is it disproportionate? Has there been bias? Has there been arbitrariness? Has there been malice? And was an adequate hearing? And if it does not pass muster, if it does not satisfy any one or more of those areas, then you may have a case that you can resolve. Right. So now you know the basis on which you can formulate a case. Now I want to, for a moment, focus on the writ of mandamus. Now, the previous elements of the case which I just discussed pertain mostly to writs of certiorari and correction, because you are looking at an illegal act which has taken place or is about to take place. Now, the converse of all this is where the party concerned, executive, administrative, or even judicial, is not taking a step that they should take. The legal recourse available to the citizen, the person, is to seek a writ of mandamus, to compel that person to take that step or give that decision. For example, let's take a very simple matter of a water connection. If you want a water connection and you feel that you satisfy all the criteria involved, and for whatever reason the water board is not doing so, then the only recourse that is available to you is to seek a writ of mandamus, to compel the water board to give you the water connection. And I think in this country, the instances of these public authorities, instrumentalities not taking the steps that they should is legion. It happens every day. Now there is a little tricky thing you have to consider, because as the law stood previously, you could only ask for a writ of mandamus if there was a public legal duty that particular authority had, which that they were not discharged. So the argument was that if they have a legal duty to do something, but you are not discharging that duty, you have a writ of mandamus available. But if it was a mere discretion, a power given to that particular authority, that you can't compel, because it is a discretion. They can do it or not. So that was the limitation with which previously the courts granted. But thankfully, that position has also now evolved. And the courts no longer insist on a public legal duty. I think one of the reasons is also the way in which laws are now enacted. If you look at all the statutes, all the laws, you will find in those enactments there are provisions which speak of the duties of that particular institution. And there will be a separate section which provides for the powers. So there was a clear demarcation of powers and duties. But if you look at the more recent legislation, you will find that there is no provision which gives the duties of these institutions. They only speak of powers. So if this old jurisprudence was applicable now, and a writ of mandamus was only available in respect of public legal duties, you would get no. Because there would be nothing to learn. So now, the judiciary, being aware of this, their wisdom through a series of acts of activism, have now evolved the law to say that no, it's not just duties which can be enforced by a writ of mandamus. Even a discretion, a statutory discretion, if it is not being reasonably exercised by the authority, you have recourse to a writ of mandamus. So as the law now currently stands, you can seek a writ of mandamus even in respect of instances where the public authority or person is not exercising their discretion, their power, reason. So now the law is quite wide. Then a small procedural issue which I would like to discuss. Previously, the law said that you can only seek a writ of mandamus, because that is to compel something. You can only seek a writ of mandamus against a natural person. You can't seek a writ of mandamus against a corporate one, university or a municipal council, for example. And the reasoning for that was, well, if we issue a writ of mandamus to compel something, and if that is not done, we should be able to punish that person for contempt of court. And therefore, a writ of mandamus could only be issued against a natural person. But that has also now evolved. And now the courts have held that you can seek a writ of mandamus even against a corporate body. So a university, for example, or a municipal council. Any corporate body, you can issue a writ of mandamus. Then the question can be asked, If you are seeking a writ of mandamus against a particular public officer who is holding a public office, whether it can be nominee office, whether it's by name of that office, can you seek a writ of mandamus against a secretary to a minister as opposed to Mr. So and so, Miss So and so, and would that be the case? Now, that is still not fully defined. Although the new Supreme Court rules, the Court of Appeal rules allows you to name respondents, official respondents, nominations, without actually giving a name, it's still a little unclear and unsettled as to whether, because if you are writ of mandamus, you have to name them. So I would say, as a matter of caution, out of an abundance of caution, if you are seeking a writ of mandamus against a particular public officer holding a public post, name it, because it is not. Now, let me just consider the area of intervention. As you know, unlike in a fundamental rights case, where there is specific constitutional provision for parties to intervene, be heard, even if they were not originally parties to the application, that is in terms of Article 133. When it comes to writ applications, there is no provision in the law, either in the Constitution or in the Supreme Court or Court of Appeal rules, which allows intervention. So there has always been this discussion, this debate as to whether in a writ application, intervention is permitted. For a long time it was allowed, on the basis that the courts have an inherent power to do so. But then there was, towards the end of the beginning of the 2000s, there was a pushback, particularly by the Court of Appeal, saying, well, no, this has allowed for various busybodies to intervene into these applications and be hearings. And there were a series of cases in the Court of Appeal, including a divisional bench, but it said no. Interventions are not allowed in writ applications. And that was the applicable authoritative law up to a point. Then what happened was, there was one of those refusals which was, or rather one of those instances where the intervention was allowed, which was challenged by the respondents before the Honorable Supreme Court, on the basis that the divisional bench judgment was clear that interventions are not allowed, which was allowed by the Supreme Court. So now, as the law stands again, interventions are allowed in a writ application. So, if you feel that you have a client who should be heard in a particular writ application, that is certainly allowed. And I think that is very important, because there was at some point a tendency for collusive applications to be filed in the court, particularly LBO matters, where two parties would have an agreement and come before court and get various judgments which would apply to other people, affect other people who would otherwise have no say. So now, in the Court of Appeal and also in the Provincial High Court, in writ applications, interventions are allowed. So now, that is a very basic exposition as to what writ applications are. Are there any questions? I was told that there should be some didactic methodology and I should explain questions. Does anyone have any questions? If not, I will look at the readings for it. Any questions?
How far the Supreme Court rules are applied for the writ application? How far the rules saw Supreme Court and the Court of Appeal to apply for the writ application.
Well,
Some dates, specific dates are given for filing objection.
yes, yes. So you have the Supreme Court rules which apply to all applications of the Supreme Court, and then you have the Court of Appeal. The Court of Appeal rules, one portion of those rules are in respect of application under 140, and those are directly applicable. Some judges are a little more literal than others and will apply the rules very strictly, particularly when it comes to timelines and also the fact that you have to tender certified copies of the documents that you are relying on. So it depends on the judge, but certainly in terms of procedure, the Court of Appeal rules will apply. Any other questions? You can very brief but flowing sequence of events. Because you must not have disjointed pleadings. Sometimes we see that, right? It's not chronologically in sequence, it's not factually in sequence, and it becomes very tedious for a judge to read. You must not do that. You must have very clear flowing pleadings, factual accurate pleadings, which makes you to agree. And we like to practice what is called a Brandeis theory, is to try to invoke as much sympathy, compassion from the courts as possible. So it's a soft story. But of course, it has to be said very well. So you set out a sequence of facts, and then you in some way, you don't want to say presumptuous also, but in some way, you must also introduce the law. Explain to the judges what the law is that you are referring to, what you are relying on, what should be applied. You have to be careful there because, as you know, the general principle is you have to assume that the court knows everything, the law. So you must be very careful and tread gently in that area of providing the law. So you should refer to the various elements of the law that you are relying on. And then, of course, go to your prayers. So now, when you formulate your prayers, you just bear in mind that there is no declaratory relief that you can seek in a writ application. You can only seek writs. So you have to be very specific and set out what you want. What is the writ that you are seeking? Now, bear one thing in mind. If you are challenging a decision or a determination, which is often the case, other than writs of randomness, you have to present to the court what that decision is. The decision that you are challenging has to be before court. If you don't have the decision, if it has been communicated to you in a way that it is not possible for you to present it to court, you must plead and say, I do not have the order at hand, I do not have the decision, and you call for it. So the Court of Appeal has held, if you must present the order, the challenged order to court, if it is not there with you, you must invite the court to call for it. So that has to be there, and be very, very, very specific as to what the relief is that you are seeking. And there are instances where the courts have dismissed applications purely on the basis that it is vague, that it is not formulated in a manner that the court can act. Now, of course, there was one particular case which came up fairly recently, Richard's case, where that is now held as a precedent to show that the courts can be very expansive in how they can give you a justice, and that they can expand even beyond that also. I've been told that my time is over. So thank you very much. If there are any quick questions, I will take it now. Yes.
We support on the very first day and we have to give notice to the other
Yes.
But after we support it, do we have an opportunity to object to that?
Yes. Now, as you quite correctly said, when you are seeking interim relief, you have to notice the respondents beforehand because at the stage of support, they have a right to be heard. Technically, they can only object to the interim relief. But what we have seen, in fact, in reality, what happens is they object to both the interim relief and even the issue of the notice. But now the courts, I think, out of deference to the fact that let's not have a multiplicity of proceedings, might as well hear them on the merits as well, and then it will assist us to even decide the issue of notice. So, in practice, what happens is they are heard on both the interim relief and also the issue of the notice. You had a question?
When respondents are objecting for application, sometimes some respondents used to say in the petition where they don't have any objections. So in that event, is it sufficient to tender only an affidavit, or do they have to tender some other documents as well?
No, you have to, in terms of the Court of Appeal rules and also the judgments, a respondent, if you are filing pleadings, you must file a statement of objections. It is nominally called a statement of objection, but we find it every statement of objections also has to have a prayer. And if it happens to be a respondent who is sailing with the petitioner, you will find that the prayer says, make such order as is deemed necessary by law. Normally, if you are a respondent, you will say dismiss the petition, dismiss the application, reject it in the brief, all that is there. But in these instances, where the respondent is saying, there's just a prayer saying, because there is no compulsion as to how you should frame your prayer. So in these particular statements of objection, which are nominally so, the prayer is make such order as is deemed just by the court, without saying this is there. And of course, an affiliate is necessary, because otherwise there is no affiliate. Any other questions? Okay, thank you very much. Oh, I know it's a sleepy time of the day. Thank you very much, and if you want to ask any questions at any point, you're most welcome. Thank you.
Thank you, sir, for that inspiring and thought-provoking lecture. Now I will formally invite Sri Lanka, convener of the Webinars and Legal Symposium Committee, to hand over the clock of appreciation to you, sir. We will now be posting this session for a short break of 30 minutes. The next session is scheduled to be commenced promptly at 11:40 a.m. And we kindly request all the resident participants to hand over your rooms and be seated at this hall until this next session begins. So the upcoming session promises to be engaging and insightful. A special handout will be distributed during this session as well. Thank you, and we hope to see you all soon at 11:40. Thank you.